We are live. This is actually my first time going live, and it's going to be interesting when I'm breaking down this Dior lawsuit. They sued a local coffee company out in Massachusetts for trademark infringement. And for those of you who don't know, I am an intellectual property attorney with almost 10 years of experience in the game. And I do everything from trademarks to patents to copyrights, trade secrets, so much more you see here in the background. I have a few degrees that kind of is giving you my credibility. I went to the great undergrad institution of Michigan State University, where I got my engineering degree as well as my law degree at Michigan State University. You see the plaque up above of my jersey, where I also play football at Michigan State, is my patent registration number, or that certificate that I had to get. And this one is going to be interesting one. I think it's going to be a mixture of entertainment as well as education. And I understand that it's difficult. It's difficult. As an IP attorney, I try to bring you guys these videos and educate you guys on the value of IP. And this stuff is extremely valuable. It's very valuable. And I'm trying to bring you guys information as it relates to intellectual property. But man, I understand that it's tough to build a business. It's tough to protect your brand and build a business based off of your brand. It's a very tough thing to do. And you have to deal with the customers, the vendors, employees. It's a lot of stuff that you have to deal with when building your brand. I will say that it is worth it. However, it's some things that you can do, especially as you're starting out, to not put yourself in the hole. We had a case back, several months ago now, where you had the YouTuber Tasha K, and she was going up against Cardi B, where she was defaming and saying some things that were not true for the most part against Cardi B. And she ended up, even though it seems like Tasha K is making a lot of money, she ended up having to go to, getting found guilty essentially of defamation and going to court. And part of the whole thing where you see Cardi B over and over again talk about, hey, man, let's just settle this. Let's not, do this whole back and forth thing in court. Just, hey, an apology and just calm down in things in terms of the things that you're saying, and we good to go. And she didn't do it. She doubled down, she tripled down, she quadrupled down. And what that ended up costing her is not only did she have to pay damages, but she had to pay punitive damages to actually punish her. And the reason I'm saying that is because a lot of times when you are kind of going through this stuff, you are trying to make a name for yourself, trying to piggyback off of these famous brand names, such as the Dior, such as the Nikes, such as the Starbucks and Chick-fil-A. Man, you got to believe that these famous marks, these famous brands are going to protect their intellectual property. You have to protect your intellectual property, but particularly these famous brands who have sold billions of dollars worth over the years of product, they are going to protect their their trademarks. And it's going to be beneficial to you in the long run to comply, as opposed to try to double down and make a name for yourself, because what you're going to find yourself is having to pay trouble damages, punitive damages to punish you. And it's going to make things that much more difficult when you're trying to start a business. I was actually, and I contemplated doing this video, and I chose not to do it, where it was a guy, pretty much a kid, who tried to, he literally copied the Jordan 1s. And he said before Nike came to him or sent him a cease and desist letter, hey, I'm copying the Jordan 1s. And the shoe was essentially the same thing. The only thing they had his logo, which was like a lightning bolt as opposed to a Nike sign. So Nike sent him a cease and desist letter, and he pretty much was going on social media talking about, man, Nike can suck his D and all this crazy stuff. And Nike, they were trying to resolve it amicably. They would just, hey, man, just put out a statement saying you're not going to sell shoes anymore. Let us know how many shoes that you sold, and essentially stop selling them. And things were going to be cool. They're going to wash their hands with the situation and move forward. However, he doubled down, he tripled down, telling Nike Council to suck his D and recording calls and doing all this crazy stuff. And ultimately what happened was Nike ended up filing a lawsuit against him. So now I'm pretty sure, in addition to compensatory damages, in addition to treble damages, because he knew he was infringing on their trademarks, on their trade dress, he doubled down. So they are going to get treble damages, and they're going to file for essentially punitive damages to punish this guy. And it seems like this is a similar thing that we have going on with the famous brand Dior. So Dior, we have a situation where we all know the retail giants Dior. I just showed you my cologne that I have, Dior. They sell everything from clothing to jewelry to shoes, fragrances. They sell everything. Now you have a coffee company that's in Massachusetts, a local coffee company that they're essentially using, and we'll get off into the lawsuit here as I bring it up here in a second, but they're essentially using the same marks, the same Dior Cafe. That's the name of their coffee shop, Dior Cafe. They're using essentially the same name. And what's crazy about it is, before we get off into the lawsuit, when Dior hit them with the cease and desist letter, what did they do? These guys went to go hire an attorney from Dominican Republic. How crazy is that? You don't go hire a U.S. attorney. You have these high-powered attorneys of Dior that's sending you a cease and desist letter, and the first thing that you do is go hire an attorney out of the Dominican Republic. Hey, man, it doesn't sound like a smart move to me. I think that's going to obviously not play off in their situation. I'm going to show you the emails. I'm going to show you the complaint. Let's actually bring this stuff up, man. It seems like we got some comments here. We Buy Houses, copy the Jordan ones exactly. That doesn't even sound very smart. Okay, yeah. So hey, look at We Buy House and Grove Point. Hey, they're on it. Cool Rich. Hey, I literally am wearing Dior Home Sport. Look at, I'm about to go put mine on. After I get off this stream, I'm gonna go light a cigar here. But let's bring up the lawsuit here. So you have Christian Dior, the famed Christian Dior, and we have Cafe Dior. Look, they didn't even change the name. Dior, which we all know that Dior has a trademark on this, and we'll see this here in a second. And then you have Cafe Dior, which is a coffee company. And it seems like Giselle Santiago, the individual, seems like he operates the company. He or she operates the coffee company. So plaintiff Christian Dior, by through their unassigned counsel, alleges the claim set forth in this complaint against defendants, Cafe Dior and Giselle Santiago. So let's go down to the parties. I'm going to skip the nature of the action. Plaintiff Dior is a French company that has its principal place of business in Paris. Upon information of belief, defendant Cafe Dior is a limited liability company organized and existing under the laws in the state of Massachusetts. Gives you the address here. Upon information, okay, we're going to skip that. I'm going to skip the jurisdiction and venue, and we're going to get off to the fame of the Dior mark. Now, they're saying that their mark is a famous mark, which comes with some extra benefits. Now, we all know, or in case you don't know, to have a famous mark, not only do you have to have a registered mark, but it has to have distinctiveness. And to get distinctiveness, that happens over time. We all know, I just said, if you give somebody, show somebody this Dior, let me blow the screen up here. If you show somebody this Dior mark or this logo right here, they know exactly who you're talking about. This is Christian Dior. So when that happens, that's what you call distinctiveness, or when a mark acquires secondary meaning. And that doesn't happen when you initially get a trademark. That happens over time. So this is let's go back to it. So they're saying that their mark is essentially a famous mark, which means that it's a registered mark. This is, it has acquired distinctiveness, or is a distinct mark. And then you have a couple other things. It's they spent a significant amount of advertising dollars, which that's interesting because I'm not sure if I've seen a Christian Dior advertising personally. You guys have to let me know in the comment section whether or not you have ever saw a Christian Dior advertisement. But we all know they have had a crazy amount of sales, which is another prong that you have to satisfy when you're trying to say that your mark is distinct. I mean, whether your mark is famous. So I know for a fact that they're hitting that prong where they have to show that they're selling a lot. So let's go to the fame of the Dior mark. Plaintiff Dior is a French luxury fashion house founded in 1946, which is crazy. I didn't know it was founded in 1946. That is famous for its iconic fashion designs and contour lines. For decades, Plaintiff Dior has used his name and marked Dior and variants thereof in connection with providing, among other things, fashion, clothing, shoes, leather goods, bags, jewelry, and related goods and services. Like I said, I got my Dior cologne. Seems like Cool Richie has his cologne in the chat as well. Plaintiff Dior owns numerous trademark registration for the mark Dior in the United States and jurisdictions around the world. For instance, Plaintiff Dior is the owner of the following trademark registrations issued by the USPTO. So we see here Dior, the word mark. And again, for a lot of things, let me come back to myself. When you go to file a trademark, you have to let the USPTO, which in other words is the United States Patent and Trademark Office, you have to let them know what classes you're filing a trademark in. You can't just file a trademark and cover everything under the sun. That's why you see a Delta Faucets, but then you also have Delta Airlines, because Delta Airlines is protecting the mark in the category that's dealing with airplanes and aviation. Then you have Delta Faucets is home goods, plumbing, accessories, things like that. So when you're filing your trademark, as we get back here, you have to let the USPTO know what class you're operating in. So it seems like initially well, at least for the Dior word mark, they're operating in Class 16, which is printed matter. Class 41, arranging and conducting of parties in the nature of balls and concerts, which is interesting. Class 43, services for providing food and drink. Services provided by the bars, by the tea rooms, food and drink catering. This is an interesting one because I never knew that Dior had protected their Dior mark in Class 43 that's dealing with food and drink services. So again, if you knew that or if you've seen anything, please leave a comment in the chat. That's interesting. We got TJ. We got TJ in the chat, man. That's sweet. That's sweet. So, and then they also have going down, see Dior here, Class 14, which protects jewelry. We have Class 18, which is carry-on bags, change purses, things like that. And then you have the CD. You have the letters or the acronym CD, which they have protecting the Class 9 eyeglasses. I'm not going to go through them, but you get the point. Christian Dior or Dior has trademarks on their marks, and it's in a number of different classes. So let's continue on with now we're starting to get off into the juicy stuff. Let's continue on with the complaint here. True and correct copies of the Dior registration maintained by the USPTO trademark and document retrieval service are hereby attached in Exhibit A. We're not going to look at Exhibit A because that's essentially telling you that the fact that they have these marks. Plaintiff Dior has extensively and continuously used, advertised, and promoted the Dior mark within the U.S. for many decades. I don't think we will all doubt that. Substantial amounts of time, effort, and money have been expended over the years to ensure that the public associates the Dior mark exclusively with plaintiff Dior when used in connection with fashion and couture items, related goods and services. Get a drink of my water here. Plaintiff Dior sells its fashion and couture items under the Dior mark in stores and boutiques located in the U.S. Okay, we all know that. And then, okay, so we'll get off into the infringing activities. What is defendants' infringing activities? Upon information and belief, the defendants and Cafe Dior was organized under the laws of the U.S. Massachusetts. We talked about that already. Defendants Cafe Dior uses its mark in its entirety in connection with the promotion and advertising of coffee. Let's go down to see this, man. Hey, talk about if you want to get sued, this is an easy way to get sued. October 13, 2023. This is the mark. This is included in a lawsuit where Cafe Dior, the coffee company out in Massachusetts, is literally using the exact same letters. It seems like it's the exact same style, which is a big no-no. The next month, November 6th, on their social media, hey, man, I tell you, man, and that social media gets you in trouble every time on his Instagram page. You see the CD mark here. I'm going to show you, I'm going to show you, I'm not sure if you can see in the cologne, you see the CD of the actual Dior. Looks pretty similar, man. So it ain't looking too good for the coffee company here. Let's get back to it. As shown above, in their November 6, 2023 social media post, defendants described the ambiance of Cafe Dior as luxury, man. Look at this point. Let me bring it back over myself really quickly. Sometimes this happens. I get it. Like I said before, you're trying to start a coffee company or you're trying to start a company. You want to piggyback off a national brand to get attention. That's just not going to end well for you. You're going to get hit with a cease and desist letter and have to essentially pivot anyway. And to the extent that you do get hit with the cease and desist letter, don't go hire an attorney out of the DR. Now, I'm sure I've been to the DR a couple of times, and I ain't going to tell. The DR is good for a lot of things, but hiring an attorney for a U.S. case is not one of them. Let's just say that. I didn't heard about Porta Plata and all the other crazy places that you could go to the DR. Not in the DR. I have been to the DR myself a couple of times, but you definitely don't want to hire an attorney from the DR for a trademark infringement suit here in the U.S. Let's go down here. On or about December 12, 2023, plaintiff counsel sent a cease and desist letter to the defendants requesting that they immediately cease use of the Dior mark, a true copy. Let's go to Exhibit C. Let me stop sharing my screen here. Let's go to Exhibit C. They're saying that they sent a cease and desist letter. I got all the paperwork, man. Y'all done made me work this time around. Let's go here. Let's go here. Let's go here. Let me see here, man. Where's Exhibit C? Okay, here we go. Here we go. So this is what you call, ladies and gentlemen, a cease and desist letter from the esteemed Holy and Menker intellectual property. So they deal with IP matters. Dear Miss Santiago. So they're sending this letter to Miss Santiago, the owner of the cafe company in Massachusetts. This firm represents Dior in connection with various intellectual property matters in the United States. It's telling where the headquarters are. Our client, Dior, is famous for its iconic fashion brands. I'm pretty sure the coffee company knew that. For decades, our client has used Mark Dior and variants thereof, and the Mark CD and variants thereof in connection with providing, among other things. We talked about that already, so I'm not going to go through that in detail. We went over the chart showing everything. This is a good cease and desist letter. So take notes, man. I think I was doing it in another video where a company went right and sued another company, and it didn't talk about the cease and desist letter. But before you're suing a company, you're going to send them a cease and desist letter to say, hey, just cut it out and we good. But to the extent that you wipe your behind with the cease and desist letter, now it's, company is most likely going to sue you, especially if you're talking about a big company like Dior. So let's go down here. As can be readily appreciated, CDC has expended significant amounts of time, money, and effort. Okay, we already knew that. It has come to our client's attention that you only recently opened a cafe in Springfield, Massachusetts, under the name Cafe Dior, that you promote and advertise said establishment by using the mark Cafe Dior and CD. The name Cafe Dior includes the mark Dior in its entirety, and such intentional use of same is likely to confuse consumers into thinking that your company and CDC are somehow related when they are not. So this is another good point. So this is like Pops off of Friday. The word of the day is consumer confusion, the likelihood of confusion. That's the whole essence of trademark law, is the consumers looking at the allegedly infringing mark. Are they likely to get confused thinking that's of the trademark term? You as the audience, let me know in the chat. If you're looking at this Cafe Dior mark, let's see, I'm pretty sure they have it in a cease and desist letter. So if you're looking at this Dior mark, we're seeing it below Cafe Dior. You have the CD. All this is from the cafe. Do you think that this is somehow associated with Christian Dior? That's the thing. If yes, trademark infringement. If no, then the cafe company is good. Let me know. Are you guys do you think that this reminds you of Christian Dior mark? Let me know, yes or no. So this is again the essence of trademark law is likelihood of confusion. Let's get back to. I haven't even let me go back to it. Here we go. So this is what I just was showing on my screen. This Dior mark. Do you guys think that this is the Cafe Dior mark? Does this remind you of the luxury brand Christian Dior? If yes, trademark infringement. If no, no trademark infringement. It's looking pretty bad for them guys, man. It's looking pretty bad for the cafe company. We Buy Houses said it's similar. I mean, I would tend to agree with you. It's not looking good for the mark. So let's continue to read the cease and desist letter. You and your company's unauthorized use of the Dior marks constitute, among other things, trademark infringement, and then they give a list of other causes of action. The remedies available to CDC for such unlawful activities include the recovery of actual damage, profits, attorney fees, and an injunction. An injunction is pretty much, hey, the court is going to tell you to stop using this thing. Moreover, because your infringement of the Dior mark appears to be intentional and willful, CDC may be entitled to treble damages. Anytime somebody says treble damages, that's not a good thing. That means that you're going to have to pay 3 times the amount of damages because you knew that your stuff infringed and you continued to do it. Now, if you didn't know that you're infringing another mark, then you're just probably going to get hit with damages. But if you knew that what you're doing infringed somebody else's trademark, then you're going to get slapped with treble damages, which is 3 times the amount of damages. So that's pretty much what treble damages is. Lastly, we note that federal trademark law provides for personal liability for any person who engaged in infringing activities, and that such individual to be jointly and severally liable for CDC's damages. So they're saying, hey, that's essentially the end of it. So let me stop sharing the screen. So we took a look at the cease and desist letters. So let's remove it. Now let's go back to stop sharing. Let's go back to the complaint. So we looked at Exhibit C. Wow. So we have the complaint. So this is what they're talking about. Looking at Exhibit C, which we just did. On or about, let's move on to the next paragraph. On or about December 20th, 2023, undersigned counsel received correspondence from an attorney advertising that he was authorized to contact us on behalf of the defendant to reach an amicable agreement. This can't be, okay, here we go, good. We on Dior market, true, okay, on them. undersigned counsel. So, okay, we'll get off into this. We'll get off into these emails a little later. This is crazy. It's going to start getting heated up now. It's going to start getting spicy. So, seems like the attorney for the defendant reached out to Wagner, advising that he was authorized to contact us on the behalf of the defendant to reach the best amicable agreement. I'm not sure. Mr. Mancebo's correspondence also advised that defendant Cafe Dior is in a position to sell all his rights to the company and a trade name and to contact him or defendant's cafe. So it seems like Cafe Dior is trying to do a stick up. They're saying, look, we got these rights. Yeah, you probably caught us. You know what? We'll sell them to you. Let's just give us a call. Let's work out something. Probably give us a couple of dollars. And we'll sell you the rights that we have. So that's pretty much what they're saying. So let's get back to it. Upon information and belief. Okay, yep. Let's see here. Did we? Mr. Mancebo correspondence to it. And to contact him or defendant's Cafe Dior and any concerned interest in acquiring a right registrations in a trade name Cafe Dior. So they're saying that y'all can get out up here. They're saying y'all can get these rights, but contact us and we'll go from there. So let's pull up Exhibit D. It's talking about Exhibit D. Let's see what Exhibit D is saying. Windows. Let's share Exhibit D. So remember, this is the correspondence between Cafe Dior's attorney. This is Exhibit D. Cafe Dior's attorney. Let's see here. Here we go. Exhibit D. Distinguished sirs. Man, hey, I have done a lot of dealing with foreign attorneys. If you don't know, I'm Dave. I'm an intellectual property attorney. I've been doing this for almost 10 years. I deal with everything from patents to trademarks. And a lot of times, particularly on the patent side of things, you may have a client in the U.S. who want to file in the U.S., but they also may want to file in China or may want to file in Japan or India. And I don't know anything. I don't want to say I don't know anything about the patent laws in India and all those foreign jurisdictions, but I'm not registered to practice before the courts, before the patent office in those jurisdictions. So what I would do, I would hit up my foreign associate across the river or across the pond, say in Europe or India or Japan or whatever country we're looking to file in. And I'll say, hey, can you please help us file this patent application in your respective country? And typically what they come back with is, dear sirs, or some form of sirs. So when you get a distinguished sirs or a dear sirs or a sirs, you know you're dealing with foreign counsel. Just take it from me as somebody who dealt with foreign counsel for a long time and continue to deal with foreign counsel. When you get the word sirs in an email correspondence, in a letter, you know that came from across the pond, because that's still a thing where I would probably type back to say colleagues. I don't say sirs because the person on the other side, when you say sir, that's typically, you think of a man, but the other person can be a woman. So I typically say dear colleagues. But the fact that this letter says dear sirs, it lets me know that this is foreign counsel. This is from somebody across the pond. This is not from a U.S. attorney. U.S. attorneys don't write like this. They will say dear colleagues or dear Dave or dear Mr. Spears. They don't say dear sirs. So let's go forth. I would like to greet you at the same time, inform you that we have been authorized by Cafe Dior, a company located essentially in Massachusetts and owned by Giselle Santiago, in order to respond to your communication. So for whatever reason, they hire an attorney. Do they have it even says Dominican Republic. Yeah, this is all bad, man. Do not hire an attorney in the Dominican Republic to respond to a lawsuit here in the U.S. Do not do that. You're wasting your money. You're going to look crazy. And that's just the beginning or the tip of the iceberg, as they say. So let's go. Cafe Dior is a company that is dedicated in its main activity is the sale and commercialization of coffee. So they're saying, hey, man, we deal with coffee. And he even said, essentially, say this is the corporate division from Secretary of State of Massachusetts, saying, hey, man, this is our registration number. This guy has no clue, or this girl has no clue. The word coffee belongs to the community and no individual may. I mean, this guy literally has no clue. He's talking about the word coffee belongs to the community and no individual may claim a right to its exclusive use. That is to say that the word coffee is commonly used by entrepreneurs of coffee products. Who said anything about coffee? This is why you have to hire a U.S. counsel who knows what's going on in the U.S. The U.S. counsel is saying, hey, you're infringing our mark for the word Dior. They haven't once in their complaint yet, to my understanding, used the word coffee. But this guy, who's an attorney in the DR, is talking about coffee and the name coffee and how that's used by the community, and nobody can, which he's right, nobody can claim trademark to the term coffee, but nobody talked about the name coffee. We're talking about the name Dior, which is a trademark term. So let's get back to it. Let's see what they're talking about. The distinctive Dior added to the word coffee comes from the proper name of the young Dior. So he's pretty much saying, hey, Giselle Santiago has a daughter named Dior Mercedes. And therefore, we're using Dior that comes from somebody's name. And as a result of that, we're good, which is not true. That's not a good argument. But let's continue to read. In view of that fact that according to the communication from Holly and Menker on behalf of Christian Dior, the relevant element to the purpose comparison is Dior, which is the name of. So they're saying, look it. The relevant fact, now they're starting to get it off into what the attorney is saying on the word Dior, but the Dominican Republic attorney is saying this Dior is proper because it's the name of the daughter of the owner. Are you buying that, Mark? I mean, are you buying that or not? Let me know in the chat. Do you buy this? Seems like he has an uphill battle, or she has an uphill battle. A well-known mark is distinctive sign known to relevant sectors. Okay, whatever. It is for the reason that the principle of special. Man, this guy has no. He hit up. Look at for all my real estate guys. We know what open corpus is. This guy, the Dominican Republic attorney, in their response to Christian Dior's attorney, hit them with the open corporates of Cafe Dior. No one can use the Cafe Dior name if they do. Man, this guy has no clue. No one can use the Cafe Dior name if they do not have the registration or permission to do so. This guy has no clue what he is talking about. Yeah, this is pretty bad. This is some bad stuff here. Okay, so let's continue. That when consulting with Mr. Giselle Santiago about the logo that appears in the communication of Holly and Menker on behalf of Christian Dior at the commercial establishment, she has told us that she acquired it via the internet to a third party, and upon noticing similarity, she has initiated the removal. Okay, so it seems like she's starting the removal of it and the replacement and change of the entire graphic line. And okay, so she at least saying that she's starting to remove it. She said she got it from the internet. I don't think Christian Dior's attorney nor the USPTO cares that she got it from the internet. But let's continue reading the last paragraph. In this sense, we thank you for your attention to this while informing you that the entire Cafe Dior is in a position to sell all its rights of the company, trade name. Please request that any concern of interest in acquiring rights, registration, name of trademark. That's interesting, though. So they're pretty much saying, hey, you can buy this off us. Let's go back to the complaint. Let's continue with the complaint here. Let's continue with the complaint. So the complaint had us go to Exhibit D, which we just finished reading. Upon information of belief, let's start at item 23 or paragraph 23. Upon information of belief, Mr. Macebos is an attorney authorized to practice law in the DR, but is not authorized in the U.S. For the chat who doesn't know, you have to be registered in a country in which you're trying to practice law in. So it's not, I mean, I can't go practice law in Europe or in China or in India or Japan or Mexico. I don't know the laws of those countries. So you typically hire what is called a foreign associate to help you in those countries. Seems like the DR, they're trying to save some money here. So it's not authorized to do so in the U.S. by email dated December 20th. Plaintiff's counsel requested that Mr. Macebos confirm his submission to practice law. And so I'm going to start saying the Cafe Dior's attorney as opposed to Mr. Macebos. A true and correct copy. Okay, we have that in Exhibit E. It in an email dated December 21st, 2023. The defendant's attorney provided a copy of power of attorney in Spanish. This is crazy. Document signed by defendant Giselle Santiago as a principal, Cafe Dior. Let's look at Exhibit F. I'm trying to show y'all at the very least what not to do to avoid an infringement suit, because it's not going to turn good for you guys if you do this. Let's go to Exhibit F. So this looks like an email chain we have between attorneys. Good morning, Minker. Nice to greet you. We are a Republic law firm specialized in IP, copyright, music, entertainment. So at least Santiago, or the owner of the Cafe Dior mark, at least he hired an attorney in the DR who deals with IP. That'd be crazy if this guy dealt with real estate or criminal and stuff like that. But at least he deals with IP. Wrong country, but at least the area of expertise is at least in a ballpark. In the U.S., we only have one international address. As we informed you previously, we have been authorized by the entity of Cafe Dior Company Incorporated. So we already read that. It seems like this is what they're saying was provided in Spanish. Senor Rodriguez, we confirm receipt of your letter. So this is Christian Dior's attorneys. Please advise if you are a member of the Florida Bar or the Bar of the State of Commonwealth in the United States. Let us know if you're a member, if you're barred anywhere in the U.S. It doesn't even have to be Florida. It can be Massachusetts. It can be Michigan. It can be Ohio, California, New York. Just let us know whether or not you're barred anywhere in the U.S. We note that you claim to have an office in Florida, but you do not appear in Florida's bar records. Please also advise if you are authorized by your client to accept service of a complaint filed in federal court. So, hey, man, this is starting to get spicy here. We're coming to an end here. Let's go back to the complaint here. Here we go. So we just finished reading item 24. Let's go to 25 here. By email of Mr. Masibo, essentially attorney for the defendant, dated December 21st, plaintiff counsel requests that defendant cease and desist any and all of Dior's marks. Defendants have yet to respond to said correspondence. They're talking about an Exhibit G. We're not going to do that. Let's go down and look at some pictures here. Below is a screenshot of defendant's Cafe IG post. I'll tell y'all that IG, that social media gets y'all in trouble. What does it say? On February 8th, so this was a couple months ago. Getting ready for Valentine's Day. Okay, you have some people that's got the hard eyes. Since defendant's mark, Cafe Dior incorporates the Dior mark in its entirety and is used in connection with the goods and services offered by Dior, the Dior, I'm going to start saying that like the Ohio State, the Dior, acts are likely to deceive, mislead, and confuse. We told y'all before that the standard in trademark infringement is likelihood of confusion. As an attorney, as an IP attorney, I would say that this is some confusion going on. Well, the 30 here, indeed, defendants aforementioned acts are likely to dilute. Okay, we're talking about dilute. So we're going to go through the first cause of action. There's a number of cause of actions. We're going to go through the first one, only the first one, which is federal trademark infringement. And another thing I do want to bring it back on myself, that typically all these intellectual property matters are dealt with in federal court. Go look at the IP clause of the United States, of the U.S. Constitution, Article 1, Clause 8, Section 8, is giving the federal government essentially dominion or jurisdiction over IP matters, so patents, copyrights, and trademarks. So typically, when somebody's filing a lawsuit on the that's dealing with IP, it's filed in federal court. I know a lot of times the state court is dealing with, and obviously state courts a lot of times is dealing with matters such as, you have some criminal law unless kind of get picked up by the feds, and therefore it's in federal court. And you have maybe some real estate stuff that's typically done in state court. A number of things are handled at the state court level. However, IP is typically handled, and for the most part, handled at the federal level. So I wanted to bring that up because it is a federal thing. And that's why they're saying that is federal trademark infringement in accordance with 15 U.S.C. United States Code 1114. Plaintiff Dior incorporates the allegations. Okay, yeah, we already read all that. This is an action for trademark infringement. Plaintiff Dior is the owner of the Dior registrations, which we talked about already. Defendant's mark, Cafe Dior incorporates the Dior mark in its entirety, and defendants are using the mark Cafe Dior in connection with goods and services that are identical to those provided by the plaintiff under the Dior mark. Defendants use a confusingly similar, there's that word I'm talking about again, a confusingly similar mark is likely to cause confusion, deception, and mistake by creating a false and misleading impression that defendants and goods and services are distributed or offered by plaintiff Dior. So that's cool. That's cool. Defendants' actions constitute trademark infringement in violation of Section 32(1) of the Lanham Act, for which plaintiff Dior has no adequate remedy at law. So they're saying you don't even have a defense that you can assert. Defendants' actions demonstrate an intentional and willful intent to trade on the goodwill associated with the Dior mark. And when you start saying willful, that's when you start getting into the treble damages which is 3 times the damages, defendant's cause of action are likely to continue, causing substantial injury to the public and to the plaintiff Dior, and plaintiff Dior is entitled to an injunctive relief. Pretty much, court, you need to have them stop using this mark. And that's actually pretty interesting, because they already said that they were going to stop using it. So maybe they didn't stop using it. I'm not sure. That's pretty interesting that they're kind of saying about the injunction. We're not going to read the other causes of action, but I do want to get off into the request for relief. So we're for plaintiff Dior requests that this court enter judgment in favor on each claim for relief set forth above and award in this relief, including but not limited to defendants and everybody associated essentially with the defendant, which includes but not limited to officers, employers, employees, representatives, successors, assigned attorneys, franchisees, dealers, and all others to be enjoined from using a mark, using any trademark, counterfeit mark, name, logo. Yeah, they getting with them. Using any trademark, name, logo, design, or source designation of any kind or in connection with the defendant's goods and services that is likely to cause confusion, mistake, deception, or public misunderstanding that the goods and services. So they're pretty much saying anything that you're doing with the Dior mark, just cease everything. Cease selling coffee, cease these logos that you're using at your store, cease everything. Let's go to number 2 here. Defendants to be ordered to cease offering for sale, marketing, promoting, cease what they're saying, cease promoting it, marketing it, shut down all the IG pages, the Twitter, the Facebook, all that. Defendants be compelled to account to plaintiff Dior for any and all profits derived from defendants from their use of the mark. So let us know how much money you made. You're gonna have to repay that to us. Plaintiff Dior be awarded all damages caused by the acts forming the basis of this complaint, and based on the defendant's knowing and intentional use of a confusingly similar mark, that the damages be awarded treble. There's that word treble, which is 3 times, because they knew and intentionally used the mark. Man, that's crazy. They asked for $2 million. Award plaintiff statutory damages of $2 million per counterfeit mark per type of goods or services offered for sale. Yeah, they're coming after the defendant here, the Cafe Dior. Defendants be required to pay to plaintiff Dior the cost and reasonable attorney fees. They want attorney fees. They want, plaintiff Dior be awarded pre-judgment and post-judgment interest in all monetary awards, whatever that the court deems just. So, man, what do y'all think about this? We're going to stop sharing. We wrapping up here. This is crazy. This is crazy. This is, again, what not to do. It's a ton of learning lessons in here. Number 1, again, I get it. It's tough. It's tough building a brand. It's tough protecting the IP, coming up with the IP, having great goods and services. But you have to avoid trying to piggyback off of one of these well-known brands, because you're going to get caught. And once you get caught, you're going to have to change anyway. So why not just start from the beginning on an up and up, doing something that's, or starting with a name or a mark that is yours, that you don't have to worry about the boys knocking at your door, sending you these cease and desist letters. So you don't have to worry about that. So this, hey, one of the big takeaways is let's start right from the beginning with something that you came up with. I understand you may want to piggyback off the name and likeness of a well-known brand to get that traction, but that's not going to end well. And it's not going to end well, not only because you're going to have to pay attorney fees, not only because you're going to have to pay damages for profits, but especially if you knew that this well-known mark, or any mark for that matter, exists, you still used it. What they say, you knowingly and intentionally use it, you're going to have to pay 3 times the damages. And that's going to set you further back in the hole. So that's all I would say wrapped around in the first takeaway. And the second takeaway, and this should go without saying, man, if you have a U.S. case, do not go hire an attorney that practices in another country. That's wild to me as an IP attorney. This is the first time I'm ever seeing that. That's wild to me. So I would like to know your guys' thoughts. Let's check some of the comments here, man. Okay. Like I said, okay, we got CT that came in. This gentleman be on this. I appreciate that. I appreciate that. Rich Cool, definitely. Okay, we got Diddy. They all wilding on this one. Hey, Diddy, I agree with you on that. They all wilding. My brown box, great breakdown. I appreciate that. I appreciate that. CT, that law office sound like they doing BBLs in the back. Hey, Hold on, can we share this? There we go. I like, okay. I ain't looking. This is my first time doing this, so I'm getting used to it. But that CT said that little office sound like they doing BBLs in the back. Would you say they hiding under an umbrella of IP office? They doing BBLs in the DR? I should have saw if it was a Sasua. Let's go. Let's go. This is Diddy Bop. I watch all of your videos. You are the truth, Dave. I learned so much from your channel. I believe that IP, intellectual property, trademark, copyright are so overlooked. I agree with you. I agree with you on that. This stuff is extremely valuable, and that's why I'm trying to bring value to you guys, because this stuff can change someone's life. It will change your life. You got to go about it the right way, of course, but it definitely can change your life. Let's go. Let's see what Cool Rich is saying. It's just lazy. Man, I agree with you, Cool Rich. This is lazy beyond belief. And I guess Santiago, when I was thinking Santiago, I was initially thinking that they're from Puerto Rico, which would have been better because at least that's a U.S. territory. But after further thought and the fact that they hired a law firm in a DR, that's making me think that Santiago is from the DR. Giselle Santiago is from the DR and maybe moved here or whatever. She ended up here in the U.S. and set up a coffee shop. But still, if you're in the U.S. and you're setting up a coffee shop, is it not like reasonable or like common sense to go to a U.S. attorney as opposed to an attorney back in the DR? And even further, look at a lot of people ask me, man, and this is a good thing about being an IP attorney. A lot of people ask me that, hey, I got a criminal matter, I got a maybe a bankruptcy matter, or I got a matter dealing with some form of the law that I'm not well versed in. I'm an IP attorney. I deal with everything in IP, and if I'm not well versed in it, I will refer you to somebody else. I will recommend you to somebody else. But one of the things that I'm not doing, I'm not trying to take on a case that I don't know the ins and outs of, that I'm not well versed in that area of the law, that I'm not well versed in that law in that country. So really, the law firm in the Dominican Republic, they actually kind of got down on Santiago and put her in a worse position, because if she would have came to me, like if I got a client and they're from, say, Europe, and they come to me in the U.S., they're like, hey, man, Dave, we got a dispute and it's in Europe. I'm going to say, I don't know anything about Europe. I can put you in contact with my foreign associate who practices in Europe, but I know nothing about how the laws are applied in Europe, how to try this case in Europe. The fact that Santiago's lawyer, who's from the DR, didn't do that is crazy to me, and really is malpractice. Now, I'm not sure if malpractice is a thing in the DR. Seems like based on CT, they doing BBLs in the back. Maybe it's not a thing, but this is definitely, at least at the worst, malpractice. So that's interesting. Let me go try to pull some of these other ones up. We buy houses in Grosse Pointe. Says, why people think they can just do that blindly, man? That's a good question. If I had the answer to that, I'll definitely tell you. But I think it's what Cool Rich says. It's just lazy. People trying to piggyback off of another brand, and to be honest, it end up setting them back further in the hole as a result of it. So that's my answer to that. Again, we buy houses. Is there a way to get away with it? Not at all. I think they dead to the water on this one. Let's go to Cool Rich. What are you saying earlier? I literally am wearing Dior. Hey, I got my Christian Dior. I may put this on before I go to the cigar lounge here after this stream. Let's see what my man TJ. Show it down for us. Hey, yes, sir. Big day. Man, they tripping, Cool Rich. What else he said? That's so intellectual lazy. I agree, man. That's definitely lazy. CT, this gentleman's on his game. I appreciate that, CT. Yes, it's similar, definitely. It seemed like the chat was maybe doing their thing. Diddy Bop, also known as Brandon Denson, says that they're wilding on this one. I would agree with you on this. We buy houses. I mean, that's factual if it's their name or not. Hey, what do you say? I mean, that is factual if that's their name or not. That's the one thing. The USPTO doesn't care. And if Santiago would have hired somebody in the US, they would have told him, like, okay, just because your name is, like, for example, Grant Cardone. We all know Grant Cardone, and I would imagine that we buy houses in Grosse Pointe, no Grant Cardone. He's a real estate magnate who buys all over the country, particularly in Florida and the Southeast region. And he has a trademark on Cardone Capitals, and that's part of his name. So if somebody comes, Cardone, he has the trademark on the word Cardone. So if somebody else, and that's ends up happens to be his last name, but if somebody else who had a last name Cardone and they're trying to use it for real estate or something that Grant Cardone is using it in, The USPTO doesn't care. Unfortunately, the USPTO doesn't care that, hey, this is my name. They don't care about that. All they know is this is a registered trademark. To the extent that you're using it, I get it. It's maybe your main name. It may not be your name. We don't care. I was thinking about registering my name, my last name, which you see here in the back, Spears, for future purposes. But hey, that's just the way it goes, unfortunately. So then I think we're caught up on the comments here. Great breakdown, Dave. My brown box. You have the CT talking about what he's the office doing BBLs in the back. So, and I think I'm gonna end it on that note. I would love to continue to hear your guys' thoughts and comments. I'm gonna try to do these every week. This was the first live, so I'm still ironing out the wrinkles. And they had me sweating like a Hebrew slave in the studio. But we got through it. So this is the first one. I'm gonna try to do these every week, bring you guys. I'm gonna probably title this series "Big Guy versus Little Guy." That's a big company that's suing a little guy. We all know Dior is a massive behemoth in the retail fashion industries, that, as they talked about, they're suing, a little guy, somebody who's just trying to start up their coffee shop in Massachusetts. Fortunately, that's how it goes. So I'm gonna probably title this series "Big Guy versus Little Guy," and bring this to you this every week. Bring you the complaints, bring you the lawsuits, trying to give you the tips and some tricks and what not to do, try to educate you, but entertain you as well. So that's I think that's it for today. And until next time.